My name is Emma Waldron and I'm WCVA's Risk Procurement and Governance Manager. In this session, we will be discussing fundraising and compliance with the Data Protection Act, and I'm delighted to welcome Bethan Bonsall from the Information Commissioner's Office.
Hi everyone.
Bethan will take us through the presentation, and if you have any questions, we will get to them at the end, but feel free to add them to the chat pane as we're going through. Okay, thanks all. Over to Bethan.
Thanks Emma, and thanks for you all for dialing in today on our session on fundraising and how it interacts with the Data Protection Act. I think before we make a start, it's always useful for me to give a little bit of background as to the role of the Information Commissioner's Office, because it might be that some of you have had contact with us before and are aware of our role, and others might not be so aware. So I'll just do a little bit of a brief update. So we are responsible for enforcing and regulating the Data Protection Act, the Freedom of Information Act, the Environmental Information Regulations, and the Privacy and Electronic Communication Regulations, which govern direct electronic marketing, which some of you might engage in. In May 2018, the Data Protection Act will be replaced with the General Data Protection Regulation, which brings a 21st century approach to data protection laws. So although the Data Protection Act forms the basis of today's webinar, I'll be making reference to GDPR throughout, and I'll be sticking to that acronym because General Data Protection Regulation takes quite a long time to say. Part of our role is to provide information to individuals and also help organisations as well. We adjudicate on complaints, so if something happens to someone's personal data, they're entitled to come to us and ask that we look into it. And the same if they've tried to access information from a public authority. We can adjudicate on complaints relating to that nature as well. But a very big part of our role is to promote good practice across the UK. So we do that by doing things such as webinars like today's session, and we also do general awareness raising sessions, which some of you might have attended in the past. So what we'll be covering today. Between 2015 and 17, some of you might be aware that the ICO carried out an investigation into some charities' compliance with the laws that protect both privacy and prevent nuisance phone calls. This resulted in us taking monetary action against 13 charities for not complying with the Data Protection Act when handling donors' personal information. 2 charities were fined in December 2016 and 11 in April 2017. So the purpose of today's webinar is to explore the activities that charities weren't quite getting right under the Data Protection Act and to look at why this was the case. It's important for me to stress here that the Data Protection Act is not a barrier to fundraising activities, but it does ensure that organisations looking to fundraise are aware of data protection and electronic marketing laws. During this webinar, we'll be looking at, first of all, the reuse of publicly available data. Then we'll go on to have a little chat about the Act of Wealth Screening. And finally, we'll look at the Act of Data Matching or Tele appending. But before we look into these further, let's just take a quick look at the specific area of the Data Protection Act that charities weren't quite getting right. So as many of you may be aware, the Data Protection Act itself is based on 8 principles of good information handling practice. The most relevant principle in the action that we took against fundraising practices in December and April was Principle 1, which states that all information, so all personal information, shall be processed fairly and lawfully, and in particular shall not be processed unless a condition in Schedule 2 of the Data Protection Act is met, and in the case of what we call sensitive personal data, a condition in Schedule 3 is also met. So what do we mean by fairness? When we talk about fairness, the organisation must ensure that they're transparent by telling individuals what it is exactly they intend to do with the information. The personal information must also not be used in ways that wouldn't fall within the reasonable expectations of that individual. Secondly, so the second aspect of Principle 1, in order for processing to be lawful, the processing must not break any other laws, but also must meet a Schedule 2 condition, and where necessary, a Schedule 3 condition if sensitive data is being processed. Now, there are only 2 relevant Schedule 2 conditions to the fundraising activities that we're talking about today, and those are, first of all, consent, and the second, processing based on the legitimate interests of the organisation. Any fundraising activities that are carried out by electronic means, such as text and fax, will require the organisation to seek the consent of the individual. and legitimate interest might be the relevant condition for any fundraising activities that aren't carried out by electronic means, such as postal fundraising activities. Now, it's important to remember that as we approach May 2018, when the Data Protection Act will be replaced by the GDPR, organisations who are relying on consent will find that the standard of that consent is raised to a much higher bar under GDPR. So consent under GDPR needs to be unambiguous, it needs to be granular, and it also requires that the individual consenting has to take a clear affirmative action in order to consent to the processing of their data. So pre-ticked boxes would no longer stand under the GDPR, so it's important to have a little look at your systems to see whether you're relying on consent on the basis of a pre-ticked box. And more information about that can be found on our website, in particular in the GDPR overview document. So if you go on our website and type in data protection reform, it should link to that overview document. So the fairness aspect of Principle 1 is just as important as the lawfulness part. So if you remember, Principle 1 states that all information should be processed fairly and lawfully. So if an organisation has met a lawful condition under the Data Protection Act, but they have not provided fair processing information, then it's extremely unlikely that they are complying with the Act, because they've got the lawful side, but they haven't got the fairness side. So put simply, as the quote on the screen says, unless you can satisfy an exemption under the Data Protection Act, the duty to provide fair processing will still apply. In the next few slides, we'll be exploring why some of the acts that we've seen taking place in the fundraising sector haven't quite been compliant with the fairness aspect of Principle 1, and therefore not compliant with the Act itself. So the first fundraising practice we're looking at is what you can see on the screen, so the reuse of publicly available data. The term publicly available data covers a wide range of information, and it includes, but is certainly not limited to, some of the following. So first of all, you've got information contained on the electoral roll, information included in public registers, that might be one provided by Companies House, for example. You've got information in press reports that are made readily available, and also information posted by individuals on various social media platforms. The key to remember is that this type of publicly available information is not necessarily fair game. Unless an organisation can rely on an exemption under the Data Protection Act, then they still must provide the individual with fair processing information at the point that they start using that data. They must also be able to meet a Schedule 2 condition, and if they're processing sensitive data, both a Schedule 2 and Schedule 3 condition. The next fundraising practice we'll be looking at is the practice of wealth screening. So in fundraising terms, wealth screening refers to when an organisation tries to determine someone's likely level of donation or their likelihood of legacy donation based on their wealth. It can cover quite a wide variety of activities, so it might be segmenting your databases by postcode, so more affluent postcodes are kind of separated from areas that perhaps might be less affluent. And also carrying out detailed research and data collection on criteria such as jobs of the individual, their income, their area of residence, and even things such as their family's jobs, etc. I think it's fair to say that wealth screening is a kind of processing that individuals are quite unlikely to expect as a result of donating to a charity. And for that reason, there's four data protection implications that we're going to look at now. So first of all, it's argued to be unfair because it involves the processing of individuals' personal data that sometimes includes data that they haven't provided directly to you because you've gone out to seek that information from publicly available sources. Secondly, for that reason, it's privacy intrusive. Thirdly, the organisation will still need to meet a schedule condition in order for the processing to be lawful. We've already discussed the fact that the relevant conditions in this webinar will either be consent or legitimate interest of the organisation. So it's particularly important for those relying on legitimate interest to remember that you also need to consider the prejudice to the rights and freedoms of the individuals and balance this against the legitimate interest that you're pursuing. So just remember that it's not just what your legitimate interest is, you've always got to balance that with the rights and freedoms of your donors or other people that you're collecting data about. And the last implication of wealth screening is that fairness is a big data protection implication. Individuals would not reasonably expect this activity to take place. So if your charity is to consider wealth screening, then you must inform existing or prospective donors and inform them clearly, prominently, and in a way that they will understand what this involves. Your privacy notices must be detailed enough to ensure that the individual has a reasonable understanding of what wealth screening is and what it will entail within your organisation. And lastly, the third activity that our action looked into was the act of data matching or Tele appending. Now, this involves when an organisation finds out more information about donors, such as their email address, postal address, and perhaps phone numbers, which they may not have given to you themselves. So you find that from other sources and you then add it to your records. Regardless of where you get this information from, unless you return to the individual themselves and obtain it from them, this type of processing will be unfair in most cases. Now, this is likely to be true no matter how clearly you explain it to them, because it removes the data subject's choice about what information you hold about them. Individuals might have deliberately withheld certain information from you, such as email addresses and phone numbers, because they no longer want to receive marketing via these channels. By then going on to seek that information from other sources, you'll be going directly against their wishes, and for that reason, individuals really wouldn't expect you to contact them using details that they never provided to you in the first place. Now, some argue that it could be that individuals have just forgotten to give you the information, or they've forgotten to update you if they move house, for example. But you cannot assume this is true under the Data Protection Act. Even if they have forgotten, they still would not reasonably expect you to contact them via a phone number or an email address or postal address that they never gave to you. Some of you listening today might be wondering whether data matching or Tele appending is ever okay under the Data Protection Act, and the answer to that is that in some circumstances it might be. So, for example, you may be able to use data for data matching if you're satisfied that the data source that you're getting that information from is legitimate and that the individual involved had a clear, reasonable expectation that their details would be passed on for this purpose. So an example would be if an individual has moved house and they made it clear to the source of the data by ticking a box or some other positive action that they wanted them to inform third parties of the change of address, then that could be argued that that might be fair. However, if there's no evidence of such an expectation, then that processing is highly likely to be unfair. Some also argue that data matching is needed to enable them to comply with their requirements under Principle 4 of the Data Protection Act. Now, I mentioned earlier that there were 8 principles. We've spoken a lot about Principle 1, but Principle 4 explains to organisations that they need to keep their personal data accurate and, where necessary, up to date. So some might argue that, by seeking out data from other sources, this is going to help us to comply with Principle 4. However, you can actually meet your requirements under Principle 4 without data matching, so without seeking other information. If you found out that an individual has moved, for example, you can just update your records to reflect the fact that they've moved. That will be enough in itself to comply with Principle 4. You do not need to seek out their new address unless you're sure that the source you're getting it from was a kind of legitimate source that the individual expected them to pass on their new address to you. So, what now? It's important to remember what I said at the beginning of this webinar, which is that data protection law is not a barrier to fundraising, but there are fundamental points to remember when you or your organisation are engaging in fundraising activities. The first is that Section 27(5) of the Data Protection Act states that unless a relevant exemption applies, you must provide that fair processing information to the individual whose data you are using. The second is that fairness is key, so it's not just about telling them what you're doing with their data, but making sure that the information is presented clearly and prominently. Think also about whether the individual would reasonably expect you to be doing what you're doing with their data. If not, then it's even more important to communicate that fair processing information clearly, prominently, and in a way that they can understand. And finally, ensure that you've identified an appropriate lawful basis for the fundraising activity you're engaging in. If it's consent that you're relying on, remember that the consent must meet all of the requirements set out in the current data protection law, but that those requirements will be raised quite significantly under GDPR come May next year. If you're relying on legitimate interest, then remember that you must balance your interests as an organisation against the rights and freedoms of the individuals whose data you're collecting. I hope today's webinar has been informative and that it has been a useful reminder that whilst data protection laws do not prevent you from fundraising, it does require you as organisations to take certain steps to ensure that that fundraising is in compliance with data protection laws. And finally, our website, if you haven't seen it already, has a really useful array of guidance which will help you to reach that level of compliance. So our contact details are on there as well, should you wish to contact our office in Wales, because we are always on hand to provide advice and guidance. And I think it's my number on the telephone, so on the screen, so do give us a call or send us an email if you've got any queries that you need assistance with. Thank you very much for attending today.
Thanks, Bethan. So if anybody's got any questions, can they type them into the chat pane now? And whilst we're waiting for some questions to come up, there's just one question that came up from the last desktop data series, Bethan, which was, can you explain what you mean by granular consent?
Yep, so by granular consent, if, for example, you were asking an individual donor to consent to receive communications by email, fax and telephone, for example, you wouldn't just bundle all of those conditions in. You wouldn't say, tick this box to consent to all three. In order to be granular, you would separate that out. So you would have a section where I could opt in for phone contact, for email contact, and then for fax contact as well. So if the processing has any kind of different elements to it, then split those out and make sure that the individual has more choice over what they can consent to.
So for example, they may wish to consent to marketing by text, but not by post, for example. So it's given them that option to choose which method they want.
Exactly, and it's ultimately placing the control back with the individual, which is what we want to see.
Brilliant. Okay. And then a question from Kath. How do we ensure that data is accurate, and what method should we use to update records? Is there any guidance on this?
So thanks for your question, that's a really useful one. And we've got guidance in terms of Principle 4 on our website. So the accuracy principle requires organisations to take reasonable steps to ensure that any data they hold is accurate. Now, the reasonable steps can be kind of determined on the nature of the personal data. So more sensitive type data that would have more significant consequences if it were to be inaccurate, we might expect as the ICO, we might expect an organisation to take more steps than if it might be less kind of privacy or intrusive type data. You also need to ensure that if you've got data from anywhere other than the individual, that source is clear. And you also need to consider any challenges to the accuracy. So if someone writes to you and says, I believe this is wrong, then you do need to consider them carefully and decide whether it's necessary to update that information. But as I said, all that information is on our website, on our guide to data protection.
Okay, and there's another question there from Heidi. Are there any model template privacy statements seeking consent that can be used?
That's a very good question, because I keep banging on about GDPR. The revised Privacy Notices Code of Practice on our website, so that's Privacy Notices Code of Practice, that's got some useful kind of extracts and examples of privacy notices that are, will be GDPR compliant. So that Code of Practice was updated in the last few months to reflect the extra requirements of GDPR. We've also got some really good consent guidance coming out in the next few weeks that really does explain the first question we were asked about, what is granular consent? What is unambiguous? How do I show a positive opt-in? So that consent guidance will be really useful for those of you listening today that do rely on consent within your charities.
Yeah, and also to add on that as well, on the 22nd of August at midday, we do have a specific session on privacy notices, which may be useful.
Yeah.
Okay, so brilliant. Right, there don't seem to be any more questions at the moment. So just to let you know that this session, as I explained, is recorded, and the link will be available on our website. So feel free to share this with colleagues or any other third sector organisations. Our next session is cybersecurity in July. And then, as I explained, the one after that is privacy notices. We are looking for new topics, so if there are any topics in relation to data protection